part that Mr. Belt is talking about, you can actually see it on my screen. There's a pickup truck parked in there with the two with all the four doors open. That's the spot that he's talking about.
Yeah, so a person now has to, they come up that driveway, they can clear the meter because you move the fence, and then
Correct.
behind you in the corner of the screen, I'm seeing what I'm going to call that jog that looks like it's about 6 fence
Correct.
panels. And the person then has to either, like you got a car parked there, and it looks like that person, you're saying, well, Judge, they can park, they can open the doors,
Correct.
they can access that.
Correct.
Um, it- you know, uh, and what's beyond that, Mr. When a person drives past there, do they go into like a parking space, or what's beyond that?
Correct. Correct. There's a parking space. If I move my fence according to how Mr. Bell wants me to move the fence, then the whole property becomes a shared driveway and he won't be able to park any cars, period.
And why do you say that?
Because then it'll become a chair park, then it'll become a chair driveway throughout the whole property, and then he has no private property to park any vehicles. Because
You're
there's not
thinking
gonna.
if you move the fence, because then in your view you're giving up more of your property
Correct.
to this easement, and then or to whatever we're going to call the driveway, that then you've got a right to use it too, and you're going to be contending with your vehicles going in and out. Now it doesn't really make much sense. You don't have any reason to park and utilize the house, right?
Correct.
Okay. Yeah. Well, here's going to be
And
my
there's.
my
I'm sorry.
my yeah. Go. Do you have something more to say, Mr. Renner?
No, no, no. I was just gonna say that there is enough. Uh, there's enough way to go all the way to the house, as you can see on the picture where I'm talking.
Yep. Let me go back to Mr. Bell. Mr. Bell, now I'm looking at that picture. It looks like, though I get it, there is a jog in the driveway. It's less than perfect, probably, as far as driving conditions. It certainly wouldn't meet the Michigan County Road Commission manual for roads, but as driveways go, it doesn't look like it's impossible to navigate. Am I seeing something wrong?
Yeah. Well, Your Honor, first of all, we do not want this to be an obstacle course, right?
Right.
You know what I'm saying? We
Yeah.
want to be able to, these tenants, and if I sell the property, they want to come in, park their car, and go about.
All right, guys, buckle up because this courtroom moment kicks off with a surprisingly intense property dispute. The judge studies a photo showing a pickup truck with all doors open and begins questioning whether a car can realistically navigate this narrow driveway. What seems like a simple fence placement suddenly becomes a legal puzzle about space, access, and property rights. The tension builds as both sides try to convince the judge that a few feet of land could completely change how this property functions.
Their business. And he thinks that this driveway is his. That's the problem. He doesn't understand what an easement is. It's obviously he doesn't, right? And this easement has been in place for 40 years before he bought it, before I was over there. So now all of a sudden now he wants to come in and take part of that easement away. I
Was there
understand.
always a fence there?
Never was a fence.
There always was some kind
No,
of
it
fence?
never,
Oh, it was
no.
just open land before.
Yes,
Yeah,
yes.
I
Yeah,
see.
it's been there forever. And
Yeah.
yeah, and now all of a sudden you come in and you know what a prescriptive easement is. If it's been over there 15 years unabated, it becomes permanent because that's the way these people were using to get to the backyard. And now, no matter what he says or what I say, you can't overstep the boundaries of what the definition of it is. So,
Yeah.
for some reason in his mind, he thinks that property is his. Now, Your Honor, I got to say this. I don't care what happens after that. He can gain property. You know what I'm saying? He can have whatever's over outside that driveway, and he can have whatever property for whatever his lot is. But we definitely can't have it as a hindrance to the tenants, is what I'm saying. Now look at that. That looks terrible. You come in there, you're going to hit that fence, Your Honor. I promise you. You're going to eventually, somebody's going to hit that fence, or they're going to hit the house. There is no question about it.
Well, and of course, if they hit the fence, because Mr. Miranda's fence, then he's got that of course, then the person has to deal with their car damage, but
Yes.
that he's got to figure out. I mean, to some degree, he's taking the risk. You're right, because I would agree that corner does present
Awesome.
at least, I could drive my little Chevy Volt through there 100 times. You ought to see how tight it is to get into the courthouse because it was built right after that Oklahoma City bombing, and they made a real tight turn to go in to make sure we're safe, which I
Yes.
like. But I'll tell you, you don't want to be driving a full-size pickup into our
No.
courthouse park, and it's tight as
No.
can be. So, well, here's, and I again appreciate, both parties have come in here, and you're following the law and doing this thing the right way. You're not resorting to self-help, which I appreciate. However, my order at this time is, another nature of easements in general is there is a rule that goes along with them that say they should be enforced by the law in a way that's least burdensome to the person losing property, who in this case is, not, it's not a person, as you point out, Mr. Bell, losing property. Really, this is an easement that's existed for a
True.
long time.
Right.
It's been, arguably in place long enough to be a prescriptive easement. But an easement nonetheless is a permission to utilize what they call the burdened property, which is Mr. Miranda's property. There's a second principle that goes along with them that says, well, when you grant an easement, that it should be in the way least burdensome to the property that's burdened, because after all, we're saying here that the easement works a taking of what would be the surveyed property line and allows in your case access to a rental property. However, and you identified last time the fact that, hey, there's a choke point there by that gate.
All right, guys, now the argument heats up. One side claims the driveway has essentially turned into an obstacle course, warning the judge that sooner or later someone is going to smash into the fence or even the house. He insists tenants need smooth access, not a risky maneuver every time they pull in. At this point, the courtroom debate stops sounding like a technical property issue and starts feeling like a ticking time bomb for future accidents.
Gas meter that just simply isn't wide enough to allow passage of even a wide car, and thus, that's never going to be rentable. And I ruled in your favor there. This time I'm going to go the opposite and say, though, that this isn't ideal. It does allow access. Mr. Miranda did put up a picture of a big truck there with its doors at least part the way open, even at the narrowest point of the driveway. So my ruling is that he's accomplished the purpose of that easement that you're arguing for. And after all, another thing that happens here is when a fence goes up, for example, that serves as sort of an acknowledgement to the whole world that, hey, now this easement is here. It's acknowledged by both parties, and this is going to be the line of it. I understand Mr. Miranda is wanting to protect as much of his property, even though I understand the argument there is, well, he doesn't really utilize the other end of the property. There's not that much burden on him if the fence is, 3 feet farther or 3 feet not. Nonetheless, he is giving a portion of property through that law of prescriptive easement so that you can and your tenants can have access and your business can be conducted. But I'm not going to modify the order again. He has, in the very basis sense, complied with the order because I said it's 12.6 from the meter. I didn't say about the rest of the driveway. It does appear to be passable, which is the overall intent of the order. So at this time, I'm going to decree that the order's been complied with and close the case. I know that's not exactly what you would like, Mr. Bell, and if you wish to approach me to reconsider it, or you think there's more relief to be obtained here, like I explained before, the trouble with that is, it's all a matter of weighing and balancing cases. I have had cases involving easement and lake access and stuff like that they drag on for years and they cost tens of thousands of dollars. And and I always ask the participants, well, you got to say, here's the value I'm getting out of this. Is it equal to the cost of enforcing what I believe are my rights? And I believe the base right here, which is safe passage, onto the rental property for parking, loading, unloading, etc., is protected. So I'm going to rule that it's been complied with. and close the case. And again, gentlemen, thanks for bringing this before the court as opposed to going out
Oh,
and
Your Honor.
taking matters into your own hands. Go
And I
ahead, Mr. Bell.
well, there's several cases now. Plymouth Canton versus Cryer versus Prost in 2000 that said that if someone uses a neighbor's land openly without permission and continuously for 15 years, they earn a legal right to keep using it. Also,
All right, guys, this is where the judge really starts testing the argument. Instead of immediately agreeing, he pushes back with his own real world example, explaining how even the courthouse parking entrance requires extremely tight turns. His point is clear. Just because something isn't perfect doesn't mean it's unusable. You can almost feel the room pause here because everyone is trying to read which direction the judge is leaning.
too, it
Oh
goes
yeah,
on.
no, I enforced that against the church up in Northwest
Yes,
Grand
yes,
Rapids.
yes.
I believe in easements, even at the detriment of probably a whole congregation now that is going to vote against me in the next election. So,
No, they probably won't. But also, too, it goes on to say, Your Honor, Matthews versus Department of Natural Resources in 2010 said a prescriptive easement becomes permanent after 15 years of use and passes to future owners. Also, too, Your Honor, in 1997, Sherwood versus Burrow said you don't need to be the only user, just open adverse continuous use for 15 years that becomes permanent. So anybody who comes in and puts a fence down the middle of that driveway is really going against the Michigan state statute.
yeah,
You
they're the
know,
ones that are doing the taking. Well, here's the issue with
go ahead.
easements and my you know uh, the way because I've and another thing I got to say here is I never practiced real estate or property law. As a private lawyer, I only touched on it in a few cases, and I did take it in law school because it was required. And since I got this job, I get a lot of real estate cases. I wish I'd listened better to my professors 30 years ago. But the fundamental issue I experience with easements is, of course, first of all, you got to define, what's the easement there for. And in your case, it's pretty clear. It's a driveway. It's not a road. It's not a two-way traffic or anything like that. It's a driveway that'll allow access to your property. And then, and obviously, I had a case involving some lakefront property where a guy puts a plate structure right across the other guy's easement, so he couldn't drive a vehicle down it anymore. Well, that obviously then you make the easement unusable. Well, that the other corollary of that law, like I said, when you're defining the scope of the easement, that is how wide that access road is. Because, usually when people are utilizing it in that open and notorious way, they're not putting down curbs and lines or anything like that to define the width of the easement. Then the court has to define it as a reasonable width. I'm saying the reasonable width here is to allow access. It's not, in quotations, perfect access, but I also live in East Grand Rapids. I think I've had to make tighter turns than that to get into my own garage a few occasions. It's not unknown that you have a curve or a jog in an access driveway or road. So I'm going to stick with that. I understand where you're coming from, Mr. Bell, and frustrations with it. Just know that I share those frustrations. There are about a million
Well,
cases
yeah,
out there on
we,
easement and
yeah, we
property
respect that.
laws.
We respect,
There,
no, we respect you. Also,
I
too,
wish it
Your
was
Honor.
more crystal clear.
Yeah. Also, too, Your Honor, we never did address the damages. Do you want Can I take that up in small claims, or do you want to address it,
Well,
or
I thought
because
that I said right that because Mr. Miranda did move this, and there was some argument, but the original mediator's order didn't contemplate an award of any money to either side, that I was going to stick, because at the end of the day, I'm trying to enforce that and clarify the original mediator's
true, I
order.
understand that. I understand. I respect that, but we never did address that. So what I'm saying is, I should have the right to address that. I don't know under you or in small claims. I still because we did suffer, Your Honor. We
Yeah,
really did.
well,
I mean,
and
we did.
yeah, I guess the answer is if you think that it wasn't adequately addressed or unaddressed
It
by
wasn't.
my order enforcing the mediators, and I don't have the mediators, I just have my order in
Okay.
front of me now, that you can bring it back. I don't think it's a perfect claim. I think it, may get attacked on the fact that, hey, we worked this all out before, because usually when you get an order in a mediated case, the goal is to resolve all of the issues
Okay.
arising out of that. However, I don't want to opine on the breadth of that opinion right now. I don't have it in front of me. So,
Okay. So
but
we can bring that later, you said? Because we
well,
definitely something,
I'll
Your Honor.
leave that to you and your attorneys to do an analysis and see if there
Okay.
is anything worthwhile
He
to
did
do.
say we had a case, Your Honor. He really did, because when
All right, guys, this is a moment everyone in the courtroom has been waiting for. The judge breaks down the legal principles behind easements and property rights, explaining how the law tries to balance access with fairness to the property owner. After weighing everything, he delivers a surprise. The fence placement still allows access, so the order has technically been followed. With that,